of information, plenty of questions answered, so you can save your questions for later in the Q&A, and I'll be happy to answer whatever I can help you with. If you need help or further clarification, you can always call or text our 800 number or go to our website. You can set up a free consultation with me. I'd be happy to sit down and provide more information, more clarity on this. So this is just a basic overview of the power of attorneys. So just a little disclaimer, this is not legal advice. Like I said, this is just basic general information. In order for us to give you legal advice, you need to become a client of ours, set up a consultation, and all of that. So just some basic information, some basic guidance on what power of attorneys are and how they can help you and navigate those documents. So this is being recorded, so if there's any glitches or if my computer goes out, electric goes out for whatever reason, don't worry about it. It will be recorded, and Becca can get out the recording for you if you needed the recording part of this. So like I said, let's get started. So estate planning. What is estate planning? Why do we care? Who cares, right? So estate planning is when somebody passes away, where does all of your stuff go? Your stuff has to go somewhere. If you don't tell us where it is, if you don't tell us where it goes, then we have to figure out where your stuff goes. Everybody leaves something behind, whether it's a computer, a cell phone, paperwork, something, money, houses, real estate. Everybody leaves something behind. You have to tell us where that stuff goes. If you don't have that estate plan in place, then we have to go to probate court, court costs, attorney's fees, filing fees. It's very costly, it's time consuming, and we want to avoid all that. And I always say, keep your family out of court and out of conflict. So, like I said today, I want to focus on the medical power of attorney, living will, server power of attorneys. How do the power of attorneys fit into the estate planning part of this? And I don't think this is talked about enough. It just isn't. How powerful power of attorneys are and how much they can help you and your family. So, let's talk about the medical power of attorney. So what is the medical power of attorney? It's a legal document appointing someone to make medical decisions on your behalf when you're unable to make them for yourself. So medical power of attorneys is where you name an agent on your behalf. So if you have a stroke, if you have to have surgery, you can name an agent on your behalf on how to navigate your medical decisions when you can't speak for yourself. So the authority kicks in for your agent when you're incapacitated or unable to communicate. So let me just clarify this is as long as you are competent, you can take care of yourself, the power of attorney doesn't kick in. We signed the paperwork today, it will be valid today, but their authority kicks in when you become incapacitated or unable to communicate. That's when their power kicks in. So for example, if you sign the healthcare power of attorney and I appoint my mom as my agent, so long as I can take care of myself, my mom cannot, throw me in a nursing home or throw me somewhere, throw me in the hospital. She can't just do that. So long as I'm able to take care of myself, I can speak, I'm competent, I know what's going on. My mom cannot just throw me into the hospital, throw me into a nursing home. She can't do that. Now, if I have a stroke or if I get in a car accident and I can't speak, I can't think, I can't take care of myself, now my mom can step in my shoes and say, okay, you got to go to the hospital, you got to do this, and she can help step in my shoes and help make those medical decisions when I can't myself. So one of the questions that I get all the time is, who can be your agent? Anybody can be your agent. It can be a family member, a friend, a neighbor, aunt, cousin, uncle, it doesn't matter. Usually with married couples, the spouse names the other spouse as their first agent, and then we name a backup agent. So I have a lot of clients that are married and they're with their spouse all the time. They're concerned they're going to get in a car accident together. Oh no, what happens if we're both sick or hurt at the same time? That's okay, we can name a backup person. Usually that's one of their kids is their backup person, and then we can name another backup person to that if we have to do that, or if that's what our clients' wishes are. So usually it's a spouse and then a child as a backup. But usually we want to always name a backup person just in case you and your agents are hurt or sick together, or maybe your agent just doesn't want to do it or just can't do it. We always have a backup person. So another question about the medical power of attorney, when does that take effect? And I think that's the most important thing is we signed the medical power of attorney today. The paperwork's good today, but their authority can't kick in until you're incapacitated, you have a severe illness, or you can put in your power of attorney, this starts today, regardless if I'm capacitated or not. You have to tell us that situation, but their power usually kicks in when they're incapacitated or there's some kind of severe illness. So why is it critical to have one? It's important because if you don't have one, then we have to figure out who's this person's next of kin, and we have to have a guardianship. So let's say I have a severe illness, I can't take care of myself, I don't have the medical power of attorney, and I'm in the hospital. The nurses have to figure out who my next of kin is. And then that person has to go to probate court to get court orders on how to direct my healthcare decisions. And usually guardianship happens when there are people that don't have any next of kin. Then a third party like me can go down to the probate court and get a guardianship. So if you don't have any power of attorneys whatsoever, you have to go to probate court and get a guardianship. Guardianship is a probate court case where you have to file paperwork. It's a very unique case. It's very unique because there's it's kind of hard to explain because it's so unique, but it's a unique probate court case, and there's different types of guardianships. I don't want to get all into guardianships. That could be a whole nother webinar for a whole nother day. But the idea is that there's a packet of papers that you have to file at the probate court. You have to pass a background check. You have to show this person is incompetent, mentally or physically incompetent. You file a bunch of paperwork with the court. You have to follow their process and procedures. Usually you need a hire attorney because it's a complex process. It's a very specific process. And then the court has to grant that. It's timely. It's complex. It's a lot of money. And usually you need a hire attorney to figure it out because it's a lot. So to avoid all of that, you can simply have power of attorneys. Power of attorneys are pretty straightforward. We can help you with that or explain what power of attorneys are, what the documents are. It's as simple as meeting with us, hiring us, sitting down, going over it, sign it, notarize it, witness it, bam, it's done. Versus the guardianship, that's a whole court case. You got to file it. You got to pay the filing fees. You got to get all the next of kin served. It's very involved and it takes such a long time. Power of attorneys, we sign them today. They are good today. The only difference is their power kicks in when you tell us it kicks in, or by default, like I said, incapacitated or he has some kind of severe illness. So let's go on to the living will. So lots of clients don't understand or don't realize that the healthcare power of attorney and the living will are two separate documents, and they're two separate things. So I talked about the healthcare power of attorney. If somebody's going to have surgery, if you get in a car accident, so long as I'm going to get better, that's your healthcare power of attorney. The living will, and I tell clients this, the living will is for your hospice stages of your life. When you have a terminal illness, I can't talk today. When you have a terminal illness or when you're in the hospice stages of your life, that is when the living will kicks in. So the living will is a legal document expressing your wishes about medical treatment if you become terminally ill or permanently unconscious. So, and like I said, I explained the difference between the healthcare and the living will. So if I get in a car, if I get in a car accident, and I can't take care of myself, I'm hurt, I gotta have surgery, that's the healthcare power of attorney because odds are I'm gonna get better. But if I get in a car accident and I'm terminally ill or injured and there's no hope for me to get better, that's when the living will kicks in. I start entering into the hospice stages of my life. There is no hope for me to get any better. That is the living will. In the living will, we name your contacts. Usually with married couples, it's your spouse, and then we name a backup person. It's usually the kids. But you can name anybody in your living will you can name. And with the living will, you just state your wishes and you state the people and what your wishes are for the hospice stages of your life. So it can be a spouse, it can be kids, it can be neighbor, aunt, cousin, uncle. You can name whoever you want to name. And then you state your wishes in your living will if you happen to be in hospice. Let's see. So the medical power of attorney, like I said, the agent can help make your decisions. The living will is more of, hey, I'm not going to get any better. These are my wishes, and this is how I want the last stages of my life to go. Why it's very important to have one is if we don't have anything, like I said, we have to go to probate court and get guardianship paperwork. Different types of probate or different types of guardianship cases. There's money involved, time. It's a lot. So to avoid all this, power of attorneys and your living will. So let's move on to the durable power of attorney. The durable power of attorney is for finances. So in the state of Ohio, your health care, living will, and your finances are two separate documents. So it's the reason why they're two separate documents because you can name different people, or it's also for fraud purposes. So with the healthcare power of attorney, they can't just overstep their boundaries and their powers and go down to the bank and cash out your savings account. They can't do that. So that's why we keep it separate. And you can name separate people for separate documents. And I've had clients do it. So that's something that we can discuss further, or have any questions, let me know about that. But you can name separate people for separate documents. It's your wishes. So I help guide clients, what this document means. And then you tell me, okay, I want this for this person, this for this person. So that is completely up to you, but you can name whoever you want to name. Just a little side note is please make sure that they are local and that they're in state. I have had a handful of situations where they name an agent who's out of state. It makes it very, very tricky. Also with a will, if you name somebody outside the state of Ohio, it just makes it a little bit more trickier. So try to, and I know relatives, we move all the time, and I understand that, but please try to name somebody who is local. Naming somebody, like I said, outside of the state, it just makes it a little bit more complex. But let's talk a little bit more about the durable power of attorney. The durable power of attorney, just think money. Just think about money and finances and property. So the durable power of attorney is a legal document granting someone the authority to make financial or property decisions on your behalf if you become incapacitated. So the durable power of attorney involves managing your property, whether it's money, real estate, clothes, cell phones, electronics, your online accounts, the internet, anything. It covers, our durable power of attorney covers all of that, all things. Stocks, bond, anything, any type of physical property or money, just think about that. That is what the financial power of attorney covers. So the authority for that remains in effect even the person becomes incapacitated. So what that means is when we draft the durable power of attorney, this is our client's decision. Do they decide, okay, if I sign this today, do I want my agent to have the authority to have access to my property today? Or you can tell us, no, I want them to have authority when I'm incapacitated. Or with the durable power of attorney, it can be, I just want my husband to have authority just for this week or just for this month. So the durable power of attorney is actually pretty cool because we have a little bit more control over what your wishes are. We can limit the scope, we can broaden the scope, we can put in different types of dates. I had a situation where the client was going out of country for the month and wanted to name her daughter as the power of attorney for finances until she got back. So we drafted and crafted it towards her wants and her needs. She gave power of attorney to her daughter for a month, and then she came back and it was revoked. And then she had full authority over her stuff again. So there's many different types of situations that we can use the financial power of attorney. I see it a lot in real estate. So if somebody comes incapacitated, they can't sign paperwork, your power of attorney, as long as it says in the power of attorney that you have authority to sell real estate, you can do that. But it's very, 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 very important in any of these documents that you read them fully, especially with the financial power of attorney, because it covers, usually we just do a broad scope. We just cover everything, regardless if it's painting, signs, shirts, everything. It just covers absolutely everything because you just don't know what's going to happen in your life. But you can also limit the scope. But it's very, very important to read over this paperwork so you understand the authority that you are giving these people or these loved ones. and they can be revoked at any point in time, so long as you are capacitated and you understand what you are doing. So if you believe somebody is overstepping their authority, or you feel like, they're just mismanaging stuff, so long as you're capacitated, you can revoke it. It's very simple to revoke. You can also change your agents. So let's just say, maybe somebody got divorced and they don't want their spouse to be their agent anymore. We can always update that, and vice versa, but we can always update that, and it's flexible with your life. But once somebody becomes incapacitated, terminally ill, now pretty much the paperwork is set in stone. If there's any problems, then you need probate court to help fix the paperwork, and that's a whole another conversation for another day. But it's very, very, very important to read these documents and to understand what these documents do. And like I said before, if anybody needs any clarity about these, you can always go to our website, set up a free consultation. I'm more than happy to provide any clarifications or anything like that about these documents. But why is this? I guess the biggest question that I get from clients too is why is this so important? Like how, usually with estate planning is when somebody's dead, not when somebody's alive. So I call these power of attorneys, they're living documents. They are living with you. They're flexible with your life. We can update them. We can revoke them. But they are absolutely amazing. I will tell you the story about my dad. My dad was in the hospital dying, and I told my mom, you better get a power of attorney while he's still alive. And so we were able to get my dad to sign it, and we were able to help manage his assets and everything before he passed. And we didn't need probate court because my mom got the power of attorney. I helped my mom with all the paperwork and everything. We got everything in order. And then a few weeks later, he passed away. If we didn't have those power of attorneys, we would not have access to what we needed to have access to. And we would have been in probate court. It would have been a complete mess for my mom. So it's these documents are very, very important. Professionally, personally, I know it's so important, and it's so easy to execute these documents. It's not a problem at all. Another thing they're really good for is if you own and operate a business, you can name power of attorneys in case you are sick or ill or anything like that, so that way somebody can step in your shoes and help manage your assets, your business, or anything like that. But they are a great tool if we know somebody is passing away, somebody's going to be permanently in the nursing home. Okay, they have these assets. Instead of just having them sit, we can actually, your agent can step in your shoes and help manage those things for you. So if you do need to sell the house, if you do need to sell the vehicle, you can. And there's such great tools. They're one of my favorite documents about estate planning. So, but yeah, they're absolutely amazing. I would have to say pretty much every single estate plan I've done, we do power of attorneys, and I highly recommend them. You cannot go wrong with power of attorneys. You can't. So I didn't know if anybody had any questions. Feel free to ask some questions. And like I said, I have some other questions that clients ask me all the time. So do we have questions?
Yeah, there was one, and actually I was wondering this. You talked about like it's more complex if the agent is from out of state. Would you be able to just kind of high level state what one of those complexities might be? And is it complex only for Ohio, or is it all states? Like say for instance, my mom's in Iowa and I'm her power of attorney. What would some of the complexities be?
I guess it boils down to healthcare or finances. When I've seen it, like where we're at, like Huntington Bank is really popular here, but it's not in other states that I know of. So if your mom is only banking at Huntington and you're out in California, it just creates a little bit more problems. Does that make sense? Is it impossible? No, it's not impossible. I just know it's so much easier when you are local. When you're in probate court and you're out of state, that's a completely different situation, and that's very complex as well. But that's what I've seen it is, the bank needs me to go there and sign paperwork. And if you're out in California, Huntington Banks, or in Northeast Ohio, and it makes it hard. Banks make it hard for everybody. but anytime I've ever dealt with something like this or with probate, I've had to go physically go down to the bank and sign paperwork and stuff like that. With real estate, I mean, and I'm just trying to think of some other things. I know with real estate, a lot of that can be done online, so that shouldn't be too much of a problem if you needed to sell something with the real estate. Vehicles are very state specific. So if, if your mom has vehicles out of state, you're going to have to go to that state and sell them or probate them. I've had a lot of issues with vehicles, and that goes with RVs, ATVs, boats. It's very state specific.
Cool.
I hope that
Another one just
I
came
answered that
in.
question.
Yeah,
Yeah.
yeah. It says they're wondering if you can explain the transfer of items like a safe deposit box, a deed of a home, etc., if a power of attorney is in place.
Transfer of assets.
Like a safe deposit box. So would the power of attorney have uh, mm,
Like cover the power of attorney cover that. So
yes.
if your mom has a safety deposit box, we have to look at your financial power of attorney to make sure you have access to that. So if your mom does have that, make sure it's in the paperwork, and then you take that paperwork down to the bank. You physically pretty much probably have to take that down to the bank and say, hey, mom gave me access to this.
Okay.
And then the transfer of what else?
What about like the deed of a home?
So with the power of attorney, this is for the state of Ohio. For the power of attorney, the power of attorney needs to be recorded at the recorder's office. Then once that's recorded, then you should have, if the paperwork gives you the authority, then you should be able to sell the real estate. If if
Okay.
the if the paperwork gives you the power, you should be able to do it. But it has to be recorded first before you sell the property.
So basically, if I came to you and I was like, "Hey, I need you to fill," or here's me and my mom, and we want you to, she wants to make me the power of attorney. Here's all the paperwork. We sign it all. Then you send it down to the recorder's office, and then I have a copy with me. So if anything happens, I can go to the bank with my copy. And if it has something to do with like a deed of a home, then we can just go to the recorder's office. Correct?
Yes, and if clients want us to record the power of attorney, we can do that as well. But that's got to be recorded in order to sell the real estate.
Okay.
Was there another question?
That is all that has come through so far.
Okay, I just saw three. I just wanted to make sure we answered all three of them.
Yes.
Okay. So a common question I get is who should I appoint as my healthcare power of attorney? And I talked about this before. You can name whoever you not want to name. It can be a family member, it can be a friend, it can be a neighbor, just so that it's a person that you trust. And a lot of things that I come across is people don't know people's phone numbers, people don't know people's addresses. So please make sure whoever you name and decide to name, we need their name, we need their address, and we need their phone number. We put all that information, their contact information on the paperwork. Please make sure that is updated. If somebody can't get a hold of your agent, it kind of defeats the purpose. So please always make sure phone numbers are updated, addresses are updated, names are updated. I know people get married and change their name, so please keep that updated. But yeah, you can name whoever you trust. And also I get the question of, does my agent need to meet you? Does my agent need to come to the office appointment? No. So we do not represent your agent. So we represent the person who is signing the paperwork. That is our client, not the agent. So if it's a mom and a son, and the son's going to be her agent, the son does not need to be there. I just need just the mom, just the client. Um, but I always tell clients, make sure that you notify your son, your loved ones, your agent, hey, this is who I name. So I mentioned that, and I had a handful of times where clients were like, uh-oh, I thought she wanted to be my agent, and then I told her, and then she said she didn't want to do it. So make sure you have a conversation with this person or the person, a backup person, and just let them know, hey, I want you to be my agent, something were to happen to me. make sure they're okay with that, because sometimes they're not. So then we need a backup person. So just be mindful of it. But I've seen it happen a handful of times. Another question I always get is, can I choose more than one person to act as my power of attorney? So I do not like naming co anything. I don't like co-owners. I don't like co-power of attorneys. I don't like co-trustees. I don't like co-executors. I don't. The problem is that I tell clients there's too many cooks in the kitchen. We need one boss. If we have two bosses and they cannot agree, what do we do now? Now we're in court, and now we're fighting in court, attorney's fees, court costs, time spent, conflict. Keep your family out of court and out of conflict. So long as everybody gets along, nobody cares. So both of your kids get along through this whole entire process, nobody cares. But if these two kids are fighting, whose decision controls? It creates so many problems. And I know that there's a handful of clients that I've met and helped, and they really want co something. I put additional language in there. If there's any fighting, we still, this one person's going to be the boss. So I like one person to be a boss, but I do not like co anything for that specific reason. Let's see here. Okay, another question I get is, what happens if I don't have the power of attorney? What if I don't have a healthcare power of attorney, or living will, or financial? If I don't have these, so like I said before, if you do not have power of attorneys, and we need to sell mom's house and she can't sign power of attorney, we have to go to probate court and get a guardianship. So we cannot do anything without court permission. It's complex. Usually you need an attorney to file the paperwork because it's complex. It's a very involved process. You got to pass a background check. It's a pay court costs, attorney's fees. It's a bunch. So get those power of attorneys so you don't have to go through the probate court process.
I got one more question. If I am primary power of attorney for my parent and my brother is the secondary, do I need to have any special paperwork to pass responsibility to him in the chance that I'm incapacitated or unavailable, or will it transfer automatically to him?
Um, this is not for now. This is for if she were to get sick or hurt or she can't do it.
Correct.
So,
So if her mom's like, if she's a power of attorney for her mom, but then suddenly she gets incapacitated, her brother's the secondary, does it just automatically shift to him, or does she have to have any paperwork in her stuff that says that?
yeah, so I mean, if I always recommend updating the paperwork. So if her mom is able to sign paperwork and say, hey, my son needs to do it now, 9 times out of 10, we update the paperwork if that's possible. That way, everything is updated. We have the most recent contact information. If that can't happen, a mom can't sign stuff, it should be automatic. Your brother could submit, medical paperwork, or heaven forbid a death certificate or something to the bank or something to show, hey, she can't do it anymore. But that usually it's automatic. But I always recommend, if possible, keep the paperwork updated as much as possible. So we would just remove the daughter and put the son as the agent. It's just cleaner. It's easier. That's what we try. That's what we try to do.
Cool.
Okay.
Well, it is 12:30. So hopefully that we answered everyone's questions. If not, you can always, reach out, email Amy at art@equus.law, and let her know if you have any additional questions. But besides that, I think this concludes our awesome Wednesday monthly seminars about estate planning.
Yes, thank you so much.
Well, thank you, Amy.
Thank you. Bye.